Welcome to our presentation on the pros and cons of probate. As I mentioned before, I'm assuming you have or want to have a written will. Again, consider your will a letter to the probate court telling them how you want your property distributed upon your death. Assuming you have no spouse at your death, assets that are in your name alone will go through probate. If you missed it, you may want to review the first presentation on wills and intestacy, which defined probate assets. The advantages of probate are obvious. The probate court is going to supervise the work of your executor and the distribution of your assets. Your executor will have to prove to the court that whatever was in your name upon your death has been distributed to the beneficiaries named in your will. The executor will have to give an accounting to the court that everything has been done to the letter. Probate provides comfort to individuals who need that kind of reassurance. You may be one of them, especially if you have a complex estate. For example, probate requires that your creditors have time to make claims against your estate. Some professionals want this to happen after their death, so no further claims can be made after their assets are distributed to their loved ones. Probate gives creditors their chance. Once probate closes, their chance is over. Also, if there are disputes among your heirs, the probate judge is available to settle them. Also consider what executors have to do administering a complex estate. They have to make sure your real estate and personal property is insured and protected between your death and the distribution of that property. They must find an attorney to guide them through the probate process. Discover the whereabouts of safe deposit boxes and their keys. Notify your insurance companies and those who hold your savings and investment accounts of your death. Review your tax returns to see if your estate owes anything to the government. Handle funeral expenses. Make a list of your assets and debts for the attorney's review. Handle the sale of real estate or other assets that must be turned into cash before distributions are made to your loved ones. Deal with any possible estate tax. You may want to have the court make sure all this is carried out in a public forum with experienced counsel at your executor's side. That's what probate is for. The cons of probate are also obvious. Probate costs money. In California, for example, the attorney who takes your estate through probate is allowed to charge a percentage of your gross estate. That's the market value of what you own without subtracting your debts. For example, $1 million estate carries a statutory fee to the attorney that adds up to be about $23,000. So if the only asset in your name at your death is your $1 million home, and the home has a $500,000 debt, the statutory percentage is applied to the $1 million, and the attorney will get $23,000. Your executor could get $23,000 as well, though executors who are family members often waive this fee. You can negotiate in advance with your attorney regarding the fee, but it's difficult for most probated estates to avoid attorney fees. There are court costs as well, paper shuffling fees that can add up. Also, probate takes time. In California, the estate must remain open for 4 months so creditors can review it. Then your heirs must wait for the court to set a time for a formal hearing. The months go by. Attorneys tell me that a probate for an estate without problems will take about 8 months, but I've seen lots of people roll their eyes at that estimate. They have waited a lot longer for final distribution. Also, probate is a public proceeding, and your will is on file and open to anyone who cares to read it. Though probate may be a very good thing in some cases, most estate planning attorneys encourage most of their clients to avoid it. How do you do that? Some people see joint tenancy as the answer. Again, joint tenancy, sometimes called joint tenancy with right of survivorship, is a way of holding property. If you and one of your adult children, for example, hold your home as joint tenants, your share goes automatically and without probate to your child if and when you predecease them. So why not hold property that is in your name only in joint tenancy with those you want to receive it at your death? Well, a retired fireman did that with his daughter, his only child. She became a joint tenant with him on his home. A great way to avoid probate, he thought. A few years later, he wanted to sell his home. The daughter said no. Complications ensued. A married couple did the same for their son. A few years later, he plowed his pickup into the back of a car and was sued by the driver. His share of their house was now an asset the driver he hit could go after. These are some reasons that attorneys often discourage their clients from using joint tenancy as a probate avoidance device. Make sure, however, you don't decide for or against joint tenancy without seeking professional legal counsel first. In fact, don't make any decisions based on anything you hear in a bare-bones presentation like this without professional legal counsel. There are other ways of avoiding probate beside joint tenancy. Giving things away while you're alive is one. When I recorded this talk, the law allowed us to give $13,000 a year to as many individuals as we would like without any tax consequences to us or to them. A wealthy person, for example, could give away $1.3 million by distributing $13,000 each to 100 friends without any tax consequences. That's $1.3 million out of the estate that will never go through probate. Most of us are too worried about running out of funds in old age to consider a strategy like that. But if you're feeling generous and want to pass on assets to your children, and you think you can afford it, be careful about what you pass on. You may be doing your children a great favor by giving them appreciated real estate while you are alive. Be aware, though, that if they decide to sell it down the road, they may have a capital gains problem you never wanted them to have. Appreciated property that we give away during life brings with it our low tax basis. For example, I give $13,000 of appreciated stock to my daughter while I'm alive. If I bought that stock for $1,000 and she sells it for $13,000, she's going to have to pay tax on the $12,000 of appreciation, the difference between what she sold it for and what I bought it for. I made a gift to her, but I also stuck her with my low-cost basis. If that same stock passes to her after my death, she gets what's called a step-up in basis. It's as if she bought the stock from me at its fair market value of $13,000 the day I died. If she sells it for $13,000, she will have no capital gains tax to pay. One attorney told me of a client whose mother wanted to make deathbed gifts of appreciated property to her children. The dying mother was desperate to avoid probate. The attorney told the client of the capital gains tax they would face if the mother was alive when these gifts changed hands. It was too high a price to pay. So, summing up, if you die with a will and substantial probate assets, you're destined for probate. Probate has its benefits, court supervision being among them, but it can be costly, it's always public, and it moves at its own pace, not yours. Many assets, IRAs, insurance policies, pay-on death accounts, assets held in joint tenancy, pass without probate to those we want to receive them. You can also make outright gifts during life, and those assets will never go through probate. But there are drawbacks. You may regret having your children as joint tenants on your house. You may not be able to afford making large gifts to them during life. Finally, appreciated assets given away during life force your low cost basis on the recipient, which may trigger an unwelcome capital gains tax on them later. So if you want to avoid probate, what can you do? In our next session, we'll look at the revocable living trust, perhaps the most effective way of avoiding probate. See you soon.